Hi, good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge. Does he need to be brought out, or do you, I don't know your process.
Mr. Jones, please. Yeah. It's only fair because it's his case, so we might as well bring it up.
No, he asked me to do this, and so I told him I would.
Yeah, it's Michael Jones.
Yes, Michael Jones.
He must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay?
Stuff that we right back there. She's gonna read it again, okay?
Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No?
Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then
Right, but then cops get up there.
and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, "I'm the police, stop." We don't live in that kind of society. "I'm the police, I need to investigate you, so therefore stop," all day long. "I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter," all day long. But hey,
So-
I'm the popo.
The reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes, Lord.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only,
right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know what the trespass was. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
I didn't hear what happened. You were Mr. Deshawn. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Your Honor, on March 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle make an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. The defendant then traveled 88 miles per hour in a 50-mile-an-hour zone and made an unsafe lane change while speeding.
That's it?
Yes, Your Honor. The information, the charging instrument alleges that
Oh.
the reckless driving is based on a willful and wanton disregard for the safety of persons by driving more than 35 miles over the posted speed limit.
I'm going to do this. I'm going to take more time with yours. Just take a seat for me in the jury box so we don't forget about you, Mr. Deshawn. I'm not ready to make a ruling on this yet. Grab your stuff. Just hang tight with me. Can you point him something real quick?
Reckless driving, Judge Reed. Do you want him up?
No. I had a bit of an issue with this. So that's why I wanted to appoint him someone to see. Can you read me the DIMS again, Alex? please?
Yes, Your Honor. So on March 27, 2025 in Harris County, Texas, officer observed the vehicle made an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. Defendant then traveled at 88 miles per hour in a 50-mile-per-hour zone and made an unsafe lane change while speeding. Also, I watched the video for this one, so I can answer questions on what actually was observed or what I observed on video.
So let's break it.
Complaint, it basically alleges unsafe lane change. It doesn't really.
Is that the basis for the reckless driving, the unsafe lane change?
So the way that the charging instrument reads is essentially word for word is a reckless drive vehicle in willful and wanton disregard for safety of persons and property by driving more than 35 miles per hour over the posted speed limit, making unsafe lane changes, causing other drivers to have to take evasive action and avoid collision with the defendant's vehicle.
Is that what you saw?
As I did not observe any vehicles having to take evasive action. What I observed specifically was the defendant coming out of the parking lot on Theater Road. He does cut across 3 lanes to go to the far lane, but I didn't see any vehicles having to take evasive action, slam the brakes on. In terms of speeding, I'm not sure if he was speeding or not, but it did look consistent with the flow of traffic with the exception of passing other vehicles.
I'm going to admonish you.
I think that's fair, Your Honor.
Come up. Who is it again?
Brandon?
Mr. Deshawn, do you watch the news?
Yes, sir.
Do you really?
Yes, sir.
Do you really watch the news? Every single day in our county, someone dies because of a boneheaded move that's made in a car. Every single day, not just one, multiple lives are taken on our streets just because people drive in such a manner that they end up killing someone. Yours is not the worst. and I'm going to find no probable cause. But be safe. We're not asking for much. Don't drive unless you have a license. Don't drive unless you have car insurance. I tell you, I get so many emails every week because people, how can you help me? Because I have someone that's suing me for $50,000 because I got into an accident, a crash, and I broke their car. They literally ask me to represent them and help them because they don't know where to go to, where to turn because someone filed a lawsuit against them. If someone does that and you get a judgment against you, you're hosed. Get car insurance. And when you drive, do it in a manner that you're not going to injure or kill someone. We're not asking for much. All right.
We had a conversation about that already, Judge.
Be safe. It's not much. If you got to get somewhere in a hurry, leave earlier. All right. All right. I'm going to find no problem causing your case. All right. Take care. Be safe. If I see you back, it's not going to go. All right. Please.
Thank you, Adam.
Thanks, Alan.
Judge, I'd like to challenge PC on this new charge.
Okay. Have you heard it yet?
I mean, I've read it.
Okay. That's why I wanted to know whether you've read it or not. Okay. All right, Mr. McCollum, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens if it goes to trial. So just, it's okay. But just from now on, all right. So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was...
Well, it looks like the offense. So per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was.
A tense courtroom hearing took a dramatic turn when Judge David Fletcher confronted defendant Genesis McCollum over repeated violations of his bond conditions. McCollum's GPS ankle monitor had reportedly gone offline multiple times, leaving authorities unable to track his location for hours and even days. While the defendant insisted the monitor was malfunctioning and claimed he tried charging it regularly, the judge wasn't convinced. Prosecutors explained that pretrial services repeatedly contacted him about the issue, yet the device continued failing. As McCollum attempted to defend himself, even bringing up school and family responsibilities, the judge sharply questioned why the monitor kept dying if he was truly following the rules. Frustrated with the repeated excuses and violations, Judge Fletcher ultimately lost patience, declaring, "I'm putting him in jail." The explosive exchange highlighted how seriously courts treat bond conditions and electronic monitoring violations, especially when defendants are already facing multiple criminal charges.